Okie dokie. So I forgot that the video just carries on while I'm not here. Oops. Cookies. Let's turn that off. Right, let's turn this off. Yeah. Right. We're going to look at, or start, charitable trusts. Charitable trusts, and just make note, this is 2 weeks, or this will be spread over 2 weeks, but I've split it up here in that we're going to be looking at the public benefit aspect. You'll hear me talking about a case, Land Revenue Commission's in PIMSL or PIMSL's case, that lists a bunch of purposes, but for the time being, we're not going to delve too far into PIMSL's case. That's the stuff for next week. This week, we're going to look at one component of it, and we're going to be looking at charitable trusts in the broad sense, how they're set up, and really the formalities and technicalities in relation to those things. Because you may or may not be aware that there is a regime for charities. Most of us have got an idea what a charity means in the lay sense, and we have probably reached this point where we're starting to understand terms that involve the law and entities in the law differently from most of our lay friends, our non-lawyery type friends. And one of the things to note is that this definition of charities in the federal context is actually quite recent. Recently that they've gone through and really tried to tidy this stuff up. And certainly since after I did learn and study trust law. Okay, so when we've been talking so far about trust with a charitable purpose, that's trust like we understand a trust. So again, we're thinking here of express trust, things that have been set up by a person, a settlor, who has property and has intent, but doesn't have beneficiaries. It must have this charitable purpose. And that purpose we have to analyze in terms of it's what we call its public purpose, which is the stuff for next week, but also the public benefit component. It has to have those things, but it has to have those things to exist as a trust in equity, in the general law. But there's also some other statutory things that sit on the top, because not all charities are trusts. In fact, this piece of legislation, which is the superset, it's the broad non-for-profit piece of legislation that the Commonwealth government's talked about or mapped out about 6 or 7 years ago, this Australian Charities and Not-for-Profits Commission Act. They define the term entity really, really broadly, so it can include incorporated bodies, non-incorporated bodies, bodies incorporated under statute, bodies incorporated under either the Corporations Act, state, or the state acts, or any of the state or federal statutory regimes that set up a body. It can be unincorporated societies, and it can be individuals. And for our purposes, the last line here, it can also be a trust itself. So that idea of entity as defined in that particular piece of legislation is very, very expressed in very, very broad terms. But its sibling, in terms of the charities stuff, is the Charities Act 2013. And that gives a little bit, narrows the scope somewhat in terms of what a charity, for the purposes of federal legislation, is. One of the very unfortunate things, this is an area where the states and the federal government did not come together, did not map out some sort of Australian Consumer Law or Corporations Act type regime to map this thing out and make it the same everywhere. It's all over the show. And so when it talks about in any act, an entity is charitable if the entity is a charity, what they mean is in any federal act. Nothing to do with the states, sadly. But make note that you can have non-for-profits that aren't charitable, the James Cook University Law Student Society. And you could have an individual who does things that would otherwise be charitable in terms of purpose. It won't count under the Charities Act, because it excludes individuals, political parties, or government entities. Okay. So basically it's a system of registration. You can go, set your thing up, have some charitable purposes, and again, I'm thinking any of those types of categories. Trust is one of them, but also incorporated associations, unincorporated associations, bodies politic, and so on. You can go and set these things up. They have to be registered to get all of the good stuff from the Commonwealth. Now, you may or may not get certain exemptions under the various state legislation, and if you've had to go through and read some of the state taxation legislation, like the Duties Act 2001, it is a dog's breakfast. So I've probably expressed all of these things there in very vague terms. Charities are generally exempt from stamp duties. Charities have some exemptions in terms of rates because they're actually done on a case-by-case basis. So you go through the taxing statutes in all of the jurisdictions, they literally will write, in this section, this will apply to a partnership that's set up for charitable purposes, but not a corporation set up for it's just... We don't teach state revenue law at JCU. I believe they do at other institutions, but it's a bit of a nightmare. Maybe we should teach it, actually. Would anybody interested in anything like that? I suppose there's not many people that do tax here anyway. Most of you guys who are in third year is going to do tax next year. Is anybody here in third year have the opportunity to do tax next year? Because if you're not doing it, you should be. That's really, really useful. It's the only subject which is cost neutral. In other words, you do the subject, you pay $1,500 or whatever it is, and then you do a tax return and you get back X number of dollars extra because you know all the rules. And then next year, you do the same thing, and then the year after that, and it turns out you pay tax until you die. Very, very worthwhile, even if it's just for solely financial reasons. Okay. I mentioned in the previous recording, actually, about perpetuities. So charities aren't subject to the perpetuities rule. There's a thing called the CIPRE. I probably pronounced that wrong. Anyone speak French? Some French. Sarah's not here. No. CIPRE. That's a doctrine we'll talk about next week, and to push a charitable purpose to another purpose, which is kind of similar. There's a whole bunch of rules for that. And but generally, both state and federal governments know that charities do good work, and they do good work often by reducing the cost of doing stuff to the taxpayers. That's a really important consideration. If you have a charitable entity which is going and doing things for homeless people, or doing things for sick people, or doing things for education purposes, that benefits the community at no cost to the taxpayer. And so both state and federal governments are very much aware of that, and they, as a result, kind of bend over backwards in terms of how they go about helping them out. And so here, charitable trusts. The trust can be charitable. It need not be registered. So you can have a trust which satisfies all of the rules of common law and equity to be deemed to be a charitable trust, which, as we know, 3 certainties and any of the other little finicky formality requirements. But essentially, intention, set law for an express trust, and in our case, charitable purposes. That's really that's how that goes. I made the point for those who are doing admin law with me, where we're talking about standing and who is the upholder of the public interests. It's the Attorney General. The Attorney General in admin law never gets involved because it's almost always government decisions from a minister who's best mates with the Attorney General anyway, because they sit together in cabinet. Maybe they hate each other, who knows? But largely they follow the same political will. In the domain of trust law, though, in terms of charities, the Attorney General or representatives of the Attorney General do step in and do take actions in regards to charitable trust and charitable purposes, again, for the public good. So under the general law, it is the Attorney General and only the Attorney General, but the statute broadens that power, so they get a lot more scope to delegate that power to sue to other persons, including interesting persons or similar charities. It can also give the charity itself standing to sue. That again, that can be. I'm not sure how that works with trusts. So I guess the trustee gives itself standing to enforce things. So you'd be giving the trustee the power to actually go and sue on behalf of the beneficiaries. Not sure who they're suing, but see the point. All right, now these two limbs. Two limbs? No, I suppose they're not limbs, they're elements. You've got to have both of these. You have a charitable trust. And again, it's really unfortunate. These words are used in different ways in different places. Sometimes it'll just be a public purpose. Sometimes it says a charitable purpose. But fundamentally, it has to be in one of the defined categories of what we consider to be charitable. Okay, that's this first element. Which is the one we're going to talk about largely next week. I've sort of written them the wrong way around, I suppose. But all charitable trusts, as part of satisfying the beneficiary principle, must achieve both of these things. One's not sufficient. Must be both for one of the defined charitable purposes, and it has to be of benefit to the public. All right, has to have this public benefit test as part of it. It actually flows from this, which I've got it up there, the Statute of Charitable Uses, which is quite sweet. A very, very, very old statute. So I'll just briefly talk about the charitable purpose, because we kind of need to know it, at least in brief, before we can talk about the public benefit, because this actually requires this as knowledge. But next week we'll be talking about these 4 or 5, you could say, categories. And they come from this Commissioner for Special Purposes of Income Tax in PEMSL, or just PEMSL's case. And Tom used to make quite a terrible joke in all of his recordings across all the years about when students come to the exam and they write pencil case. Like, clearly you weren't turning up. PEMSL's, P-E-M-S-E-L. Or just PEMSL's case. I've referred to it in the slides later on. It's just PEMSL's case. And they looked at this ancient statute from, I said, the reign of Queen Elizabeth I, that says, in order for it to satisfy this charitable purpose element, it has to be in one of these 4 things. It has to either go towards the aged, impotent, and poor. They say sometimes that's for the relief of poverty. Sometimes it's called that, relief of poverty, that first limb. These are limbs. You only have to prove one of them. That's the first one. It has to be, or alternatively, it can be to advance education and things related to education, or it can be to advance religion. The purposes of advancing religion is one of the valid purposes in PEMSL's case. And or the 4th category, which is the broad or open-ended category that says for other purposes beneficial to the community. And some examples are building public works, building community centres, doing things around the community. And Parliament's jumped in and realised that those are a little bit narrow. And I said, I don't recall this from when I studied this as students. It's probably in the last 10 years. Added a 5th category. This is the Queensland Parliament that's jumped in and done this, because the federal definition of charitable purpose has many more categories. But here we're concerned about trust law. Trust law is Queensland law. So just make note that when we're thinking about trusts and we're thinking about whether they're charitable or not within the meaning of trust law, you've got to use these ones. You can't use the broader, 13 categories of what it is in the federal statute. I haven't put them on a slide. You can go and have a look if you like, but that is not going to apply here for trusts. And this fifth category that the Queensland Parliament, in its infinite wisdom, decided to plop in was just to do with creating infrastructure or doing things regarding leisure time stuff. Recreation, equipment and facilities to do with leisure time and recreation things. We're in Queensland. We like doing things outdoors or indoors. It doesn't specify. Provided there's some social welfare component to it. Doing things, giving them to kids on the street, get off the street and go play. Building them a little BMX track or something. That'll be fine. Okay, so you just have to note that I refer to these as the limbs of Pemsl's case. All right, and I'll try to remember that fifth one, but largely I'm here just talking about the four long-standing, old-school categories that come from the, again, this statute from 1601, I think it is. All right, so those are the purposes. That's the first component. So you need to know those, the limbs of Pemsl's case, plus the extra fifth magic statutory one for sport and leisure stuff. Okay, now we're going to look at the other element of a charitable trust, which is you need to satisfy the public benefit component. Because you can have something for the advancement of education. I pay for my kids' university fees. Is that going to be charitable? No. Sure, it's for the advancement of education, but there's a private benefit to that. It's going to one person. That is not going to be charitable. And that kind of makes sense logically, but as we're aware, when life gets in the way and things come up to court, it's only the corner cases and the difficult cases that the courts have had to map out for a long time. So, start with these Re-Income Tax Acts case. That was, or involved Freemasons. They were arguing the stuff they were doing involved in the community. They had stuff to do with the community in their particular building. What was the problem? You had to be a member. You had to be a Freemason or family of a Freemason to enter it. And there, the court sort of laid down or repeated this rule that said, look, that's, if there's some condition of entering, that's not going to be of public benefit. It's not available for people of the public to go through and do it. In particular, that case, you have to sign up to be a Freemason. Probably be different if, for example, you had to go to the Mayo lecture. There you go. And the Mayo lecture, assuming we're trying to argue it's a charitable thing for whatever reason, and you had to sign up online. You don't have to pay anything, you have to sign up online. Does that restrict? Not really. No, it doesn't. So just make note that here you had to sign up to be a Freemason. And they said that that restriction, that bar is too high. That's not going to be public for the definition of a charitable trust. But we'll note here where it's got, and in the next thing on the slide, it talks about the first three limbs of Pemsl's case. And they say that look, by default, if you are doing one of those three things, it's actually a rebuttable presumption. We actually consider, at law, or the courts in their equitable jurisdiction, consider things that are done that advance either the relief of poverty, advance education, or advance religion. Those three, by default, are presumed to have this public benefit. It's actually a rebuttable presumption. Usually it's the other side who doesn't want it to be considered to be public. It's the one that has to come along and prove on balance of probabilities that it's not. So just note there's an onus reversal here just for those three, not for the fourth one. That's not, or largely because you've got to prove the thing is beneficial to the community as part of that itself. Okay, and the third one here, when we look at the definition of public can be overseas people as well. In fact, Pemsl's case itself was the courts were looking at it was to do with the charitable aims were for the, I think it was something like the furthering the education of peoples in heathen nations. Yeah. And there they said, look, that's fine. That's fine. But when we're talking about public purpose, it doesn't have to be public within the state of Queensland or the Commonwealth of Australia. Outside this jurisdiction is actually fine in terms of how we go and do trust. Now, the reverse of that's a little bit trickier. What if the trust is outside of Queensland and the things are happening in here? It was like, well, what's the problem with that? Which jurisdiction are you bringing the action in? Because if you're trying to bring action in Queensland that a trust was created outside, but it's created in another jurisdiction, you'd have to go through and examine whether or not that's going to be valid under the laws and the rules here anyway. What's your jurisdiction? Okay, Gilmer and Coates and Crowther and Brophy are to do with religious-y stuff. Something like this. Gilmer and Coates was a case involving a cloister of nuns, and they were trying to argue that in their closed little cloister group of nuns that would come together and pray, and they were praying for the benefit of humankind. Now, what's the year? 1949? Okay, 1949 is probably mankind, despite the fact they were all nuns. Okay, sure. And so the argument that they said when they trotted up, and a lot of these cases, by the way, are also cases if you're interested in the history of religion in regards to the law as well. These are the cases that follow those things up, Bowman as well, which is last week. And the courts, they try to be very respectful in these sorts of cases. And there they said that, look, we don't know and can never really know whether you praying for the benefit of all humankind actually benefits them or not. We can't tell. There's no litmus test. We as a court don't know whether this does benefit all of personkind. We don't know. We can't tell. And as such, we have to look at what we can see. What we can see is 20 nuns sitting in a little cloister with the doors closed, trying to argue that this is charitable. And there we say no. Public can't come in. There's no direct public benefit to doing this. Those ceremonies are only listened to by those in and around. Can't get in. Public can't walk in and listen to it. Therefore, not going to be good enough. And the reverse of this happened with Crowther and Brophy. There was a trust, amount of money that was left in trust was something absurd. It was like £100,000. Oh, pounds? No, dollars. And they said, look, we will pay a stipend to every sermon that includes as part of this mass prayers specifically for our sisters who died, specifically. All right, and so the problem here was $5 goes to a minister who does one of these things, and there was $100,000 left to do this. What's the problem with that? How are you going to ever exhaust this money? I don't think they could exhaust it. No one wanted to do it. It was just that was the difficulty they had there, and they're trying to work out where they could place cypre to put it elsewhere. But first thing they had to do was say, well, is this actually of public benefit? And there the court said, yeah, it is. Sure, as part of the ceremony, you are doing this thing referring to these specific people, and you could argue there might be some private benefit in terms of calling out the names of your deceased sisters and praying for their souls. Sure, there might be some private benefit, or there might not be. We can't tell. What we can tell is that these ceremonies are open to the public. Anyone can walk in and listen to it and feel moved. So those two are kind of good in that they sort of contrast each other. One was trying to be, in the religious-y sense, for the benefit of all people, but was behind closed doors. And the other one was trying to restrict the prayers to these specific people, but they were in public. And courts can't know the spiritual value of stuff And so they decline to examine that component. They just look at what actually happens in the world. Okay, this final point here, when I say final point, there's still more slides, sorry, is to do with easing the public purse. And it seems a little bit intuitive, and it is quite intuitive, I think, that systems that are set in place by private entities, private trusts in what we're analysing here, that ease the burden on the public system. And so in LA3014, there was a trust that was set up for the benefit of a private hospital. Was a private hospital. All right. Now the thing was, it was a non-for-profit, and part of when they did make a bit of money, they could use that and put it back towards trying to take the burden off the public healthcare system. We will take people. And again, I don't know. It's possible that's how the MATA runs. I don't know. Maybe other people in the room that can enlighten me on that. I don't know how that works. But there they said that is going to be fine. It's going to be fine in satisfying this public benefit test, even though strictly speaking, it's a private hospital. If you are going to relieve the burden on the taxpayer, we will bend over backwards to tick the box that says that this benefits the public. Because it does. It benefits the taxpayer. In theory, that benefits all of us. It's kind of the opposite of people that want to not pay tax, that actually puts burden on the taxpayer. Yeah, they're actually giving stuff back. That is going to be fine. Okay. This set of slides was much shorter than I was expecting it to be. But I'll talk about this test in Compton's case. A key thing to note is that when you've got, you're trying to argue that there is public benefit for a specific trust, if the particular defining characteristic of the purpose, or how that particular benefit is going to be enjoyed by the community, if it's tied to a personal quality that can't be enjoyed by members of the public, it's usually not going to be of public benefit. What do I mean by that? It means, and again, this was Compton, was to do with employees of a particular company, employees and or their relatives and dependents and children and spouses. And so in a situation like that, the courts look to this particular quality and try to work it out. And again, thinking back to that Freemasons case, can I easily sign up to this thing and enjoy these benefits? Or is it an inherently personal quality that I cannot sign up to? All right, and so that's something that the courts look at. And there is an aspect of degree. Again, the Freemasons, becoming a Freemason, that's too high a bar, not public benefit. Coming to the Mayo lecture, arguably, even though that you do have to register, very low bar, doesn't really become a personal quality of one of the persons who may or may not form part of this group. I don't want to use the word beneficiaries because that would be wrong and really confusing. Person who's the recipient of the charitable outcomes. And what they said in Oppenheim and Tobacco Securities Trust is that it actually doesn't matter how large the category is. The Tobacco Securities Trust was was established by British and American Tobacco, and they said, or tried to argue, that this is going to be charitable because it's given to current employees, ex-employees, no matter how long ago, and their descendants, no matter how long ago. And that turns out that group of persons was 110,000 people. Okay, and then so you've got a very, very large, and in some places you could literally go to some towns in Virginia on the eastern shipboard of the United States where that's literally the whole town. It's the whole town. Everybody there would fall under this category. But there the court said no. No, it's still not. This is still a personal quality of these people. It's a personal quality. It's not something that we can just walk in, sign a piece of paper, and it doesn't really impact us in any way. Me signing up to the Mayo lecture doesn't really become a personal quality of me. Me signing up to be a Freemason kind of does. That kind of makes sense in terms of that connection. They talk about this nexus of personal qualities. Okay, and so that's the test. They call it the test in Re-Compton. Okay. I think that final sentence on that slide would have been the last one that I was writing at 11 o'clock last night, and I suspect that I was half asleep. So I'll talk about this Dingle and Turner first. And it basically goes like this, that where you've got the four limbs of Pemsel's case, good old pencil case, got the four limbs. You've got relief of poverty. You actually probably should think of these as almost hierarchical. Relief of poverty is kind of at the top. Then you've got the advancement of religion and education. They're kind of in the middle. And then you've got other purposes beneficial to the community down the bottom. And probably these days, the fifth one from the Parliament, Queensland Parliament, has jumped, is probably on even keel with that one at the bottom. Well, the reason I say that is that the public benefit test, when you're relieving poverty, courts don't really care. They actually don't mind in terms of the public benefit whether the persons in this category are restricted narrowly. So that if it is just relieving poverty for the old people in Latrobe Close in Douglas, that's going to be fine. That's going to be fine. It's going to be fine if it's for that first limb of Pemsel's case. So notice that the rules are a little bit different for each of them. This is why we have to talk about those 4 or 5 different categories. The reasoning behind that, again, it kind of goes back to the rule in Lacra's case, and that relieving of poverty is something that takes weight off of the public purse. There's that aspect to it. And I think it's also something that goes very deep in terms of the underlying philosophy of charities in the broad sense and charitable trusts in the particular sense. That when we think of welfare, stuff that's left for others, and trusts themselves, which are created for the benefit of those, usually who can't do things on their own, we think about people who've had it rough in life. It's kind of the reasoning where that flows from there. They have put and talked about that in the Federal Charities Act as well. Trying to work out what that sentence was supposed to say, because it does still exist, the personal quality requirement, but it's very much open-ended. Like I said, the old people in Latrobe Close, impoverished people of Latrobe Close in Douglas, all right, that would probably be fine, even if there's only one person there. That's going to be fine for the relief of poverty. That's going to be fine. And so just make note when you're thinking about the stuff for next week, when we're thinking about the 4 limbs of Pemsel case plus the statutory one, that they're kind of hierarchical, and that we want to be relieving poverty most importantly. And then you've got religion and education, they're kind of important and stuff, human flourishing and all that. And then you've got these other purposes thing. And so for those top 3, the rebuttable presumption is that is for the public purpose. The other side has to come along and try to argue that. Whereas the ones at the bottom, they have got a higher bar to satisfy. To prove that something's charitable, building a BMX track, yeah, probably. Building a BMX track where the only way to get through it is through your own private land, probably not. That, I think, is my final slide. Yes, it is. Yes, it is. So, again, I finished a little bit early today. Maybe we should take some questions. Anybody have any questions on this stuff? Yo. Personal quality, well, it depends. Is the purpose, or does that involve, just generically? No, doesn't matter. It doesn't matter in the way you go and restrict that particular category. Could someone move to Latrobe Close? Well, maybe they could. For the relief of poverty, we don't care. It's very, very much unrestricted in terms of that stuff. If you'd said, my relatives that live in Latrobe Close as part of the instrument might have a harder time going through and proving that. They do lower the bar, but it's not non-existent in regards to that. The personal quality thing will form part of it. Because it kind of, we're all going to have, hopefully, does it sound hopefully? Parents who are going to be old at some stage. I think I said that right? Yeah. At some stage, we're going to have relatives who are sick. All right. And one of the rules, and this really comes from tax law for those who hopefully are going to study it next year, is that everybody wants everyone else to pay tax. And the scope of charitable entities, charitable trusts, and the rules that involve those, when we're setting stuff up, would love to be able to have a charitable trust instead of a private express trust. We've got all these exemptions. We've got all of these benefits. So if we could go through and do that, and I could just list my my sick child or whatever in relation to that, then sure, we'd be able to do that. That would be wonderful. But you can't. Otherwise, everyone would do it. Because almost everybody can think of somebody who's impoverished, is poor. And sometimes, remember, these things, we've got to look at them using objective tests. What does it mean to be impoverished in Australia? I don't know. When I looked at the amount of money, I presume some people in this room get from this building. There's this building in Aikenvale you can walk into if you're an Australian citizen and you get money. It's amazing. It's a big building. I walked in there one day and to get my Medicare card, and there were people, and you just get money. You get like a couple $100 every week. You know that? It's amazing. It's like the magic money building. And so one thing I've found as a Kiwi coming here, this country is so much wealthier. It is so much wealthier. And so to be impoverished in Australia is to be middle class in Indonesia. And so it's difficult to try and really make these comparisons in terms of the relief of poverty. That can be a difficult thing to do. And it's an objective test. What would a reasonable person think you're doing here? And how the courts go about doing that in these situations, I don't know. I would imagine that in terms of the relief of poverty aspect to it, just giving money to people who are of whatever is low income, who had a very, very close connection to you. I said all of the unemployed people of Latrobe Close. Maybe that might be too. Maybe they wouldn't consider that to fall within that first limb of pencil case. I'm not too sure. Might be worth doing a bit of research. I don't have too much else to add on that, though. So if anybody's got any other questions on that, it's look, this stuff is a little bit tricky conceptually. Once you've got your head around it, it's fine. But it is the sort of thing that will come up. Definitely will come up in your assessment. Definitely. Understanding how charitable trusts work and how they operate, and starting with fundamentally why they're there, which is to try and, for a variety of factors. We want to give benefits to people who are doing good to the world. Okay. See you guys all at the Mayo lecture tonight, eh?